Morning to our I2ers and to all of our brokers on the line. It's nice to have you guys here. This morning we've got a session from our very popular GL team. Welcome Team GL. I know we've had a few GL sessions, but they've always got a new twist to what they're about to present to us. So it's good that we've been able to, go through the whole shebang when it comes to this product line. And we've always got a great crew to represent as well. Today we've got Kim Rue and Justin Malherbe to assist us as well. Kim and Justin, can you please introduce yourselves?
Thanks very much. Hi, it's Kim Rue speaking here. I'm a partner at Webber Wentzel, and I don't think I need to say much more, but it's really great to be here. So thank you very much for the invite.
Thank you, Kim.
Good morning, everyone. Really great to be with you. It's Justin Malherbe, also from Webber Wentzel. I work with Kim and the insurance team, and it's really cool to be here at our first Tuesdays with you.
Thank you so much, Justin. Dressed like a sharp lawyer who's gonna. We love it though. We love it. You look like you stepped right out of Suits.
Where's Meghan Markle?
Yeah. No, but I think he's a lot more straightforward than Harvey and all those other guys. We don't have to worry about. So we've also got our GL team on the line, as well as our claims representatives of Harmony. We've got Melita, Ziad, Susie, and I'm not sure if Sylvie's going to join us still. But team, will you just introduce yourselves as well and tell us a bit about what we're going to hear this morning?
Thanks very much, Mamweti. We're going to be talking about social inflation. And I'll introduce the guys in a minute. My name is Melita. Social inflation is the increasing cost or escalation of insurance claims beyond what we would typically expect. And it's driven by outside factors and non-typical forces, which are becoming more powerful in influencing the size of an insurance claim, as well as the outcome of litigation. And it looks like the court of public opinion is having an impact both on insurers and on the courts of law. It's also fueled by changes in the legal system, such as contingency fee arrangements, class actions, litigation funders, and punitive damages. This is impacted further by social media and the more cynical and jaded approach that the public has towards corporations and big business. Big business is becoming the bad guy, and insurers are increasingly being seen as a bad guy as well. If you just glanced at the public comments that were on the news reports dealing with the COVID business interruption claims payouts, that would give you a pretty clear indication of what the public thought of insurers at that stage. So we're going to look at these factors in a lot more detail. And Mamweti's already introduced Justin and Kim, and we're delighted to have them. They're from the insurance team at Webber Wentzel Attorneys. So thanks for joining us. And we're going to be asking them some questions and having a chat. And this is going to be facilitated by our GL team, which consists of Susie, Ziad, and hopefully Sylvie, who's having connectivity problems, but I'll step in for her if she can't join us. And we also have Harmony from our I2 claims team, who's going to just be giving us some comment from a claims perspective as to how I2's been experiencing some of these factors at play. And so, yeah, that's our I2 general liability team there on the slide. And Harmony's there highlighted as the member of the claims team. And I'm going to be handing over to Susie, who's going to be asking some questions to Kim and to Justin.
Thank you, Melita. Thank you once again to Kim and Justin for affording us your valuable time this morning. We're going to jump straight into the Q&A session. The first question we have is for you, Kim. It's in respect of plaintiff attorneys and contingency fee arrangements. Can you please elaborate as to how these arrangements work? What is the purpose thereof? What is the maximum percentage in respect of these fees? Does it only apply to certain types of claims or classes of claims? Do they drive litigation? And if an attorney is getting a percentage of these fees, are they then likely to encourage a client to claim for a higher amount? What is your thoughts on those?
Thanks, Susie. Yeah, it's a very interesting topic, and I think what's really interesting about contingency fee arrangements is that for so many years in our legal system, it was not permitted. So it was something that we saw in foreign jurisdictions, what I call the sort of American influence into our legal system, and that American influence, which is certainly driving litigation. The contingency fee arrangement, so traditionally, a person wanting legal assistance had to engage with an attorney and would be paying a fee for that legal advice and for that representation. The contingency fee arrangement came into effect with the 1997 Contingency Fee Act. And that was the first time that attorneys were allowed to start acting on a contingency basis. So what it effectively meant was that where people couldn't previously afford to have legal representation, they could now engage the services of an attorney who could represent them on the basis of taking a percentage of the amount of the recovery from that claim. Now, the traditional type of claims where one needed to see this kind of assistance to plaintiffs was primarily in the personal injury space, because there you often had a situation where someone had a legitimate claim, had been injured, had a claim from falling off a building, whatever it may be. It was a valid claim, a legitimate claim, but they could not afford the legal fees of pursuing that claim. So there was a definite need for that in our legal system. So what the Contingency Fee Act allows for is it allows for an attorney to conduct the litigation on behalf of a plaintiff on the basis that they carry all the costs relating to the litigation. And then at the end of the litigation, on condition that the claim is successful, the attorney can then charge that client double what their ordinary fee would have been, obviously taking those proceeds out of the compensation that that client receives, or they can charge up to 25% of the amount recovered. So it's quite a significant amount that they're able to recover. So it's either double the ordinary fee, or it's up to 25% of the compensation paid to that plaintiff. There are limitations as to the type of legal matters that are subject to contingency arrangements. So, for example, you cannot have a criminal matter that has a contingency fee arrangement. A commercial matter is not permitted to be subject to contingency fee arrangements, nor family matters. So it really is focused primarily, and that's what we see, on the personal injury matters. The one thing to bear in mind for the plaintiff, of course, is that if the claim is unsuccessful and a cost order is made against that plaintiff is still liable for the cost order. So it's really important that that plaintiff has a clear agreement with the attorney as to what happens if they are unsuccessful, because you're sitting in a situation where the plaintiff can't afford legal fees to start with, and all of a sudden, if it's not successful, they could land up having to pay those legal fees. And the same would go for disbursement costs. So if the attorney has to incur costs in respect of medical experts or advocate fees, then it needs to be a clear arrangement as to who is covering those costs, and are they forming part of the contingency fee arrangement or are they not? Now, one of the things we've certainly seen is that with these contingency fee arrangements, there is an increase in the amount of personal injury litigation. And that goes without saying, because you've got plaintiffs who previously would not have been able to afford proceeding with legal action for personal injury claims, for example, who are now able to do so. One of the things that we're also seeing is that you've got an attorney who's now got a vested interest in the matter, and that one has to be very careful of, because they certainly have an interest in seeing where that matter goes. And it's quite interesting to see how that pans out, because you can have a situation where the attorney will then push the quantum of that claim higher and higher because they are going to be getting a 25% cut. They often will plant a seed in the plaintiff's mind of a claim worth a lot more than what it actually is. And the difficulty that one then has is when you try and settle a matter for a reasonable amount, that high number that's been planted in the plaintiff's mind right at the beginning is almost a stumbling block on that settlement. And that's because of that vested interest. So if you think about it, you've got a plaintiff who's suffered an injury. They go to 3 attorneys, and attorney A says, look, I can get you R1 million. Attorney B says, I can get you 5 million. And attorney C says, I can get you 10 million. Well, it's a no-brainer which attorney the plaintiff is going to go for, given that they don't have to pay anything. So they go to Attorney C, and they have in their mind that they're going to get this 10 million rand settlement payment, of which they're going to have to pay the attorney 2.5 million at 25%. Once the claim has been properly assessed, you have a look at it, and that claim is not worth more than R1 million. Now, to get into that plaintiff's head that their claim is only worth R1 million makes that settlement very, very difficult. So the contingency fee arrangement certainly has the effect of sometimes prolonging the litigation and making it more difficult to settle. On the other hand, however, we do sometimes see the opposite effect, which is also interesting, where an attorney has a contingency fee arrangement of 25% of the settlement payment. They obviously want to try and get that settlement made as quickly as possible, because they're going to get their 2.5 million rand, whether they spend a month running that litigation or whether they spend 4 years running that litigation. So the quicker they can settle, then the better. So sometimes it does play out in favor of the defendant in being able to reach a quick settlement, obviously depending on those facts. But in terms of driving litigation, driving up the quantum of litigation and driving up the number of claims, we've definitely seen an increase in that since the contingency fee arrangement came into play.
Perfect. Thank you very much for that insight. It's most valuable and very interesting. The next question is also headed your way, Kim. It's in respect of class actions. Can you please describe some of those actions that we may have had in South Africa already? Are we likely to see quite a few more of them in the future? And specifically with regards to products liability and class actions, is there anything that we as insurers and our brokers should be on the lookout for or cognizant of in terms of insurance coverages and so forth?
Yeah, thanks, Susie. Again, it's another development in our law that's had a big impact on the amount of litigation that we're seeing. So the Constitution makes provision for class actions, Section 38C, which provides for a situation where a party can represent a class of other claimants in an action. In terms of legislation, that's the only piece of legislation that we actually have that deals with class action and regulating class action. So it's been quite interesting to watch the development over the last few years. And when I say few years, I'm talking the last 20 plus years in terms of the development of our class action litigation. And the reason for that is because we don't have any other standalone legislation that deals with class action. So what we've had to see and wait to happen is for these cases to come to court and for the courts to make legislation surrounding the procedure of how to bring class actions and how they are run. So there's been a number of class actions that we've seen over the last 20 years, and I'm not going to go into detail of them. We all know the Pioneer Foods, what we call the bread case. We know the silicosis cases, the listeriosis cases. We've had more recently the Steinhoff attempt to certify a class. So there's been a number of really big cases that we've seen. And what's been really interesting is that every time we see a new case come to court, new developments and new ways of regulating the class actions come to light. So there are a couple of criteria around surrounding class actions. In other words, how one goes about certifying a class. Before you can bring a class action, the first and foremost thing is you have to certify that class. And when the courts look at certifying the class, they look at a number of criteria. They look at whether all the plaintiffs have a similar type of claim. Can you lump those plaintiffs together? Is there a triable issue that those plaintiffs have against the particular defendants whom they want to claim against? And that was the issue we had in the Steinhoff matter, where the court actually found that there wasn't a triable issue. So there was an attempt to certify shareholders as in a class action against the directors. And what the court found is that there wasn't a triable issue in the sense that the shareholders did not have a claim against the directors, and the claim actually lay in the hands of the company of itself, and therefore the class was not certified. The other things courts look at is whether the class of plaintiffs all have a similar set of circumstances. Many of you may remember the matter, I think it was in PE, the 699 matter, and this was the purchasers, the public who had purchased vehicles, there were 3 particular banks who were financing the sale of vehicles to individuals. And what would happen is they would take out the loan to finance their new car. And at the same time, they would sign a separate contract with an advertising company who would then brand the vehicle. And provided they drove a certain amount of kilometers, they had to do a certain mileage per month with the branding on their vehicle, they got paid by the advertising company. And the net effect was that they had their new car for only $6.99 a month. So that's why it was called the 699 scheme. And what happened in that matter is the advertising companies then pooled their advertising and cancelled the contracts. But of course, the vehicle finance contracts continued to run. And so you had thousands of vehicle owners who now still owed the banks money for their brand new cars, and it was no longer costing them $6.99 a month because they weren't getting the compensation from the advertising companies. In that case, there was an attempt to certify a class, and what the court found there is that each of the plaintiffs was had a different set of circumstances in relation to the contract they had taken out with the bank. And remember, in that case, what they were trying to show was that there was reckless lending on the part of the bank. And to show reckless lending on the part of the bank, you have to look at the particular circumstances of each individual who has taken out the loan with the bank. And because of that, the court said, well, they do not all have the same set of circumstances, and therefore this is not a class action. So there's been a number of different cases where courts have either certified the class or not certified the class. What we have seen in our law is that where a class has been certified, so for example, your silicosis cases, your listeriosis cases, it's been quite interesting to see that shortly after those classes have been certified, there have been settlements of those claims. So that's been very interesting to see. And the other interesting thing to see in our law relating to class actions is the difference between the opt-in and the opt-out. Now, an opt-in is where someone applies to court to have a class certified, and the court certifies that class and gives the public a certain period of time in which to opt into that class. So they will say all people with, blue eyes who purchased, this product between this period and this period, you can opt in to that class. And if you fall into that definition of the class, you can opt in. The other option is where a court says, right, everyone who worked or anyone who purchased this product from between this date and this date, you are automatically in this class and you can opt out of the class. And if you're in the class, then whatever damages are awarded to that class, you get your share of it. Now, there are some benefits as to why you would want to opt out, and that is if you think you have a bigger claim than what the class is going to get, or your percentage of what the proceeds will be once the damages are divvied up amongst the whole class. So there may be a reason why you say, I want to run my own claim and I don't want to be part of that class. What we've seen in South Africa is that there's a tendency more towards opt-out than opt-in. And that is in line with what we're also seeing globally. So the courts will certify the class and everyone is included unless you elect to opt out.
Thank you so much for that, Kim. Much appreciated. Definitely some food for thought. I don't know if Sylvie has managed to join us online, because the next few questions are headed your way, Justin. Sylvie?
Yes. Can you hear me?
Yes.
Good.
Yay. Thanks, Sylvie.
I'm going to hand over to you.
Thank you very much, Susie. My first question is in respect of litigation funders, directed to Justin. And how does litigation funding work? And if so, can anyone invest in the outcome of litigation? Are there instances in South Africa? And the last point is, are we likely to see more of this happening and more of these entities popping up? Thank you very much, Justin.
Thanks, Sylvie. Yes, litigation funding is another interesting development, sort of along the same lines as the Contingency Fees Act, a more recent entrance into South Africa's litigation and claim space. In a nutshell, litigation funding is basically an alternative way for a claimant for damages to fund the costs of a legal dispute. It can refer to not only a litigious dispute, one in front of the courts, but also to arbitration proceedings. How it works is a third party funder who is not a party to the dispute or a representative, they enter into an agreement with the prospective plaintiff or their lawyer to provide funds for the legal costs of that dispute in return for a share of the award in the event that the claim is successful. It's often described as non-recourse funding, which means that if the claim is lost, the claimant will not be liable to reimburse the funder's investment in the lawsuit. So essentially, it offsets some of the risk of the litigation for a price. Now, when we spoke about it being non-recourse, how, the first question that comes to mind is, well, how is that different from a loan? Well, with a loan, for example, if you were to approach the banks, remember there's an obligation to repay the loan with interest, whereas with litigation funding, there is no obligation on the claimant to repay the funds. And also, most times, no security or guarantees need to be provided to the funder other than the litigation asset itself. So this model, which has been quite prevalent in some overseas jurisdictions, is finally making its way into the South African space, has for about the last 20 to 25 years. Some types of claim are more suitable for this model than others. The way it's structured is sometimes the agreement is entered into between a law firm acting on behalf of a client and the funder. Other times the client themselves engages a litigation funder upfront to fund the costs of their litigation, either on an ongoing basis or to help reduce the financial impact on its operations of some ongoing commercial litigation, perhaps a very big case. Some of the types of claims where this model is often considered for use is, well, internationally, two of the big ones is patent litigation, IP litigation. So this litigation funding model is used mostly because of the high cost and high risk involved in patent litigation. Remember, you often have a little guy who's come up with an invention, and he has to go up against the very big IP product organizations, for example, big drug companies. So because of the substantial cost of these type of claims on both spending on technical aspects, technical experts, as well as damages experts, it's a very good fit for the litigation funding model. Another interesting one is in insolvency. Often insolvency practitioners make use of litigation funders because sometimes the most valuable asset in a deceased estate, or in an insolvent estate rather, is a legal claim. But the insolvent estate lacks the funding to pursue that claim and realize it for the benefit of creditors. So that's where insolvency practitioners engage with the litigation funding in order to unlock or realize that value for the insolvent estate. Also, very good application in class actions that Kim described. Often overseas, you see litigation funders entering in to fund class action litigation. We mentioned very large commercial litigation. And also what's starting to become prevalent locally is in medical negligence disputes, particularly the large complex medical malpractice matters, which are very expert evidence heavy. They require 10 to 20 experts to come and comment on various aspects of liability and quantum. So there you also find litigation funders being used. It is possible to use litigation funders for purposes of arbitration in addition to litigation. Obviously, that must be strictly regulated and be subject to the criteria that the parties set for themselves in resolving that dispute. So just how does one introduce, or how does a litigation funder get introduced into a claim? Well, often they perform their own due diligence on the underlying lawsuit. The litigation funder will appoint an attorney or a legal specialist to come and vet the claim and to advise the funder on what terms they can and should offer to the party that's seeking their assistance. Because of the commercial viability criteria that are usually applied, sort of underwriting criteria, if you like, by these funders, it's usually only large or complex claims that are right for this type of model. But there's no reason why litigation funding can't be considered for any type of dispute, subject to it being efficacious and leading to some efficiency in the legal process.
Justin, can I interrupt here? Can anyone invest in litigation funding? I mean, would it be open to members of the public if there was some sort of special purpose vehicle that was out there that the litigation funders had set up? I mean, could it be like, owning a share or something like that?
Yeah, or like crowdfunding, Melita.
Yes,
Technically,
exactly.
There's no bar on raising capital for a lawsuit by way of crowdfunding or any model like that. I think on the level of what the litigation funders do, it's unlikely that members of the public will fund litigation like that, because it's not their core business, and there has to be a rationale to it. The ability of litigation funders to leverage key legal insights into what is a viable claim, what is not a viable claim, what is likely to generate a return on investment, because ultimately they are in the business of making money. So they are looking to achieve a return through the capital of that claim. Means that, the only people that will do it professionally are these litigation funding organizations and their agents. But in theory, I mean, we often see members of the public banding together to fundraise for certain litigation. Sure. So in a way, that is on a micro level litigation funding done by members of the public.
Sure. I mean, they buy Bitcoin and have no clue, I'm sure, most of the time, how cryptocurrency works. So it's quite possible. Cool. Sylvie, back to you.
Thank you very much, Justin, for those great views. My last question will be in respect of punitive damages. The Constitutional Court has introduced an element of punitive damages. Can you give us more info on how this works? And are we likely to see other courts following the same route, like in the USA? And the last point is if insurance policies exclude punitive damages, would they also exclude Constitutional Court damages? Thank you, Justin.
Sure, those are some excellent questions, Sylvie. I think the first thing to highlight is the fact that constitutional damages will always relate to an infringement of a constitutional right, whereas punitive damages, the way that terminology is used internationally, doesn't always relate to an infringement of a right. So you mentioned the USA. They are notorious for awarding punitive damages. The law reports are rife with ridiculous examples, like the person who burned their mouth on the coffee that was too hot at McDonald's, or the person that sued the tobacco companies for not warning them of the bad effects of smoking. In those two large judgments in the past, billions were awarded in punitive damages against the defendant organizations. So therein lies the distinction. Punitive damages are basically intended to punish as opposed to compensate a victim for damages. Now, historically in our law in South Africa, our law has always been compensatory, not punitive. And there were very good policy reasons, policy considerations why that is the case. The possibility of some form of damage being awarded other than compensatory damages was actually first considered by our Constitutional Court very long ago in the 1990s. The court, in one of the seminal judgments just after the Constitution was introduced, expressly observed that appropriate constitutional relief may include an award of damages where it is necessary to protect and enforce constitutional rights. So if a person suffered losses as a result of a breach of a right in a statute, and provided it wasn't contrary to the drafter of the statute's intention, the legislature, a claim for damages was possible. The court recognized that, but it added the proviso that as to when it would be appropriate to award damages of that type and what the measure of those damages should be would depend on the circumstances of each case. And actually, this remains the position in our law even now, nearly 30 years later. And that's even though more recent cases have appeared to demonstrate a greater willingness on the part of our courts to consider incorporating this type of damages in their judgments. But there's always this proviso that it's subject to the existing requirements, that it must be case specific and in vindication of constitutional rights, not necessarily in vindication of a private contractant's rights or in delictual or tort law, the rights of a particular or individual victim. The reason why punitive damages or constitutional damages has reared its head in recent times is twofold. One very high profile award that was made a year or two ago was that of the Life Esidimedi tragedy, which we all followed, I'm sure, in the media. That matter went to arbitration, where each claimant in that arbitration was awarded 1.2 million rand in damages, of which 1 million rand was expressly for constitutional damages for the state having violated the constitutional rights of state healthcare patients. 70 patients had died when they were transferred, when a whole class of mental health care patients were transferred from Life Esidimeni facilities to private NGOs. And in the process, because due process wasn't followed, 70 passed away. So both the estates of the deceased as well as the remaining victims were participants in this arbitration. And although it was presided over by our former Deputy Chief Justice, Moseneke, it was not a litigation per se, but rather an arbitration process, which was agreed to by all the parties concerned. The result, therefore, is that the finding and the award made in that case is not legal precedent. But the facts do demonstrate the legal principles involved. As we said earlier, any award of damages that goes beyond the realms of our common law of damages would need to be based on specific facts. And in the Life Esidimedi case, you had those facts, which made it appropriate to award damages outside of our delictual framework. And lastly, the second point that makes this quite topical at the moment is that in terms of certain new legislation, it appears that penalties and court-awarded damages of a potentially punitive nature are now possible in statute, at least in theory. One good example of this is the recent bringing into force of the Protection of Personal Information Act. For breaches of the Information Act, and specifically its provisions that deal with unlawful or lawful processing of personal information, a victim of unlawful processing activities may now approach a court that is empowered by Section 99 of POPIA to award what it calls aggravated damages. And that is in addition to the normal civil damages for patrimonial or non-patrimonial loss. The Act itself contains no explanation as to what is meant by this term aggravated damages. And of course, over the last few years, while the Act has been being brought into force, there's been speculation all over that it may in fact refer to punitive damages. But for all the reasons we've just mentioned, it's unlikely that any court will depart from the existing principles when it considers what damages to award in a given circumstance where a person has been a victim of unlawful information processing. But this introduction in POPIA is perhaps a good reminder, though, to insurance people to have a look at policy wordings again, to check their application to new laws such as POPIA. While most policies tend to cover fines or penalties of an administrative nature, criminal fines and penalties are not usually covered. So to the extent that the fine or award is intended to be of a penal nature, a punitive nature, it may not be covered. For the types of events or losses that are usually covered by liability policies, however, the likelihood of a claim for constitutional damages proper arising for coverage purposes is probably still remote. So those are some interesting highlights on this topic of punitive damages.
Justin, can I interrupt again? Just on, are we likely then to possibly see plaintiffs approaching the Constitutional Court where perhaps they would otherwise have gone to one of the ordinary courts because of this punitive damage aspect? Because, I mean, your constitutional rights, I know, are specific, but you could pretty much argue that your constitutional rights been infringed in quite a lot of the litigation cases. And if you approach the Constitutional Court, then your award potentially could go beyond just pure indemnity and pain and suffering, and you could have this punitive element. I know maybe our claims team can also jump in here, but I know we've had threats to approach the Constitutional Court with some of the claims that we've had under a policy from a third party. And you can't help thinking if that is perhaps part of the thinking on the part of the plaintiff, that they would go to the Constitutional Court as opposed to an ordinary court.
It's quite true, Melita. It does beg the question whether we should expect more approaches like that in the future. Again, I think it would take a perfect storm condition for a plaintiff to get that right at the first attempt. The reason being that there are a number of safeguards or sort of barriers to entry in terms of direct access to the Constitutional Court. And if the claim still has civil nature to it, a civil claim for damages that can be accommodated in our law of delict or our existing common law of damages, the court may well insist that that claim is brought to the High Courts first. And they would be reticent to recognize a claim for constitutional damages where there is already a remedy in delict. So I think that remains the position. And also because in past cases where the issue has raised its head, our Constitutional Court has specifically said, look, we are recognizing the elements of your claim that are directed at a constitutional remedy, and we're dealing with them. But insofar as a remedy is already available in the common law, we insist that you go back to the High Court to deal with it. So I think that will continue to be the position. Again, you know, the perfect storm condition we spoke about, you probably need a class of victims to approach, and the primary or majority objective of their approaching the court would need to be the vindication of their constitutional rights, as opposed to seeking patrimonial damages. That's really how the court has sort of diced these cases in the past.
Right, great. No, thank you. That's very helpful.
Justin,
I think you had a couple of questions.
Sorry, Melita. Can I just ask?
Oh, Carmony, thank you.
A question before you go on to social media. Justin, so the punitive damages aspect will not be covered by a liability policy when it comes to constitutional damages. But when they say that the other damages would be awarded where there's no other remedy in law, then to me it seems like the liability policy is very specific to say that we'll cover you for your legal liability. So the other remedy in law would definitely relate to something that is wide of the liability policy in any event, whether or not the damage is punitive.
It may well be. Offhand, I can't remember. I'm trying to think of the examples of the IT policies I have in mind. But yes, I think that is a valid summary of it. Bearing in mind that liability policies often are based ultimately in contract or in delict. So the courts, again, are going to look at it through that lens and say, well, have you got a remedy in delict? Well, then let's talk about that. Let's not talk about vindicating your constitutional rights. Because the court has also said in some of the past awards, they've said it serves both purposes. Our law of delict is fit for purpose. It deals with both aspects satisfactorily.
Yeah, so I mean, if it has to go to the level of constitutional damages where you cannot really find a remedy in delict, then it may really fall wide of, in any event, of a liability policy.
It may. I've seen this. Sorry, Carmony, carry on.
No, if the law is to develop a little bit more, then obviously we would then have to have more robust discussions in terms of whether or not constitutional damages would fall part of the indemnity provided by a liability policy.
Agreed. I think many insurers have approached it on that basis, that look, we'll consider it as and when, you know, the first textbook case arises. I've seen it in a number of cases in medical malpractice PI defense of claims, where a large claim is made for medical malpractice against a treating practitioner, and there are elements to the pleading that lead one to believe that this matter may well go to the Constitutional Court if the claimant does not succeed in achieving adequate levels of compensation, and those compensation would obviously form the basis of indemnity under the policy. But very seldom does it get to that level, because the matters are usually adjusted or settled or negotiated before it has to go to those issues. So it very seldom arises, I think.
Okay, thank you.
Hi, Justin, how are you?
Good on you, Ziad.
Good, thanks, man. My question's around social media and sort of millennials or younger generation Z coming into big business. So with regard to social media, what sort of impact does social media have on claims and litigation? Any suggestions how to manage that?
Sure. It's interesting, because I think social media is one thing that we all in it, whether we like it or not. So we all have, I suppose, divergent opinions of it, about whether it's a help or a hindrance in our aspects of life. The one thing I thought about the way social media affects claims and litigation is, look, it definitely has a PR aspect to it. Oftentimes negative, but sometimes positive. Our courts are very wary to allowing any media to tinge or color the nature and outcome of a dispute. But that doesn't mean, and our high court judgments in the past, particularly in criminal matters, have made it clear that, you know, judges are not immune to the headlines. And if those headlines are on Twitter or Facebook, the same principle applies. So there are reasons why social media does play a role, and I think it's likely to play a role forevermore. Another way it plays a role is crowd support, leading to the formation of a class of claimants that Kim spoke about earlier. So in terms of class action formation and establishment, oftentimes this can be mobilized and leveraged through social media. We've seen a very recent example of that in the very unfortunate looting and protests that took place in South Africa in July. Social media definitely played a role in drumming up support. So perhaps in cases against the state going forward, social media will continue to have a growing impact in the way those cases are built, put together, less so as to how they are determined or adjudicated, because as we said, the courts and our legal system is expected to be impartial and blind to the court of public opinion. And just as an additional remark, it's interesting, but you know, overseas in some jurisdictions, social media can be a direct source of claims and litigation, in terms of where images are published online that have the intention or potential to harm persons that view them. This often happens in the USA, for example, where persons claim emotional shock on account of having watched images of police brutality. But again, in our law in South Africa, the safeguards are there that usually prevent it from getting that far, in terms of foreseeability of harm, would probably act as a very high barrier to entry to those type of claims being brought here.
Thanks. Thank you very much there, Justin. And my next question is regarding the Generation Z or millennials. And as these younger generations or younger people enter the workplace, become lawyers, judges, insurers, etc., are we likely to see any changes in claims and awards and attitudes towards big business and large corporations? Are law firms seeing some sort of influence being exerted by millennials or the younger generation and their anti-business sentiment? You know, will this eventually influence class actions where typically big business is or are the defendants?
Sure, Ziad, if you're talking to me, perhaps I'm not the best person to answer that, because according to the textbook definition, I still count as what is known as a geriatric millennial.
Same here, me as well.
So perhaps no one will believe what I have to say. I don't know if Kim's there. Perhaps Kim has some.
Yeah, maybe Kim, would you like to take this one, please?
Yes, sure. Absolutely. I'm not a geriatric millennial. Probably just a geriatric. But so yeah, absolutely. I think it might be a little bit early to say the exact effect we're going to have, but I must say, seeing more and more millennials coming through practice, there is a slightly different mindset. There's a lot more of an equity-based mindset. There's a lot more pushback against big business, as we all know. There's a lot more of a sense of accountability. So and environmental consciousness. So the sort of, if I can say, traditional thinking that big business can do what they want and get away with it and not be held accountable for polluting our oceans and environment, and destroying lives and injuring people and putting people's health at risk, that mindset has definitely changed. And that's what we've seen in the class actions. And I think as we see more and more of those millennials coming through, we're going to see more and more decisions changing, and those millennials will eventually take on the roles of judges in our country. I think we are going to see some changes there. There's also, I think, in the millennial generation, and I'm talking about that very broadly, is they question things. It's not just accepted. So the fact that it's been done, a certain thing has been done in a certain way for the last 50 years or however long it is no longer just acceptable. It's now questioned as to why is that permitted? Can that carry on? And there's a sense of righteousness of, if big business has harmed the man in the street or a class, there is a sense of righteousness, of accountability. And we certainly are seeing more and more of that. And then finally, I think that the American influence, and I refer to that again in terms of the litigation, the attitude towards litigation and our litigious society, we're also seeing coming through. So I always joke about the 6-year-old on the playground who's, someone stands on his toe and he says, well, I'll sue you. And one does joke about it, but there is that sense of, you do something wrong, you get sued, you do get, and that we'll definitely start seeing the impact of that as we become more and more litigious. Does that answer your question?
Yes, it does. And thank you so much
from the geriatric.
Yes, your insight and your expertise. Yeah, thank you very much for that.
Thanks, Ziad.
Yeah, Ziad, from another geriatric, and definitely a geriatric, nowhere near a millennial, other than remembering the past millennium. More clearly.
I find it hard to believe, man.
Not at all.
But yeah, Kim, I mean, I think in the US, their big concern, of course, is they have the jury system. So as millennials and Gen Zs start to enter jury, doing jury duty, you may well find the sentiments of a jury changing quite radically, perhaps from the other generations who were adjudicating a case. And I think that's their big concern. But as we know, and as Justin's pointed out, judges are not immune to having their own kind of sentiment, and as much as their legal training comes to the fore, and we're very grateful for that, as opposed to having a jury adjudicate, I'm sure it's bound to have an impact, and certainly regulators, insurance claims people, underwriters. I'm sure that we are going to see not a seismic shift, but definitely some changes into, as you say, holding people accountable, picking up aspects of social responsibility, perhaps even, what we insure, having a social conscience in terms of what we insure and how we insure it, never mind the claims aspect that comes into it as well. So I think it's going to be quite fascinating to see how the sort of generational shift starts to have an impact on claims, on litigation, and on societal issues. Absolutely.
Absolutely, Melita. Just touching on something Justin said earlier in terms of punitive damages, just something to bear in mind, and one doesn't often hear about this in the media, is that you tend to hear the story about the large damages awards being made in America for the person who burnt their mouth on the hot coffee, etc. But one doesn't often hear about those damages being overturned on appeal. So it's very often that the jury does award these, gazillion rand worth of, or dollars worth of damages, but on appeal it is overturned, and the damages are often more realistic, which of course don't make the headlines because that isn't clickbait, and nobody's really interested in that, and because that's far too realistic. It's much more the sensational story sells.
Yes, absolutely. I think, you got any more questions, or we good from your side?
That's it, Malise.
No, from me, that's it from me, Malise. Suze, I think we're going to hand over to Kamini for some more insight on social media and how social media influence claims and the like.
That's correct. That's correct. So thank you once again to Kim and Justin for your insight and most valuable feedback. It's highly appreciated. If you wouldn't mind just staying on the line a little bit longer, we just want to see if there's a few questions in the chat box, but we'll attend to that after we've had a chat with Carmini now. Carmini is our GL claims manager, and she'll shed some light on what sort of trends we've seen in our claims space. Carm, do you have any comments for us?
Sure. Okay, so with regards to the claims trends regarding the social inflation issues that we've been speaking about, so contingency fee agreements for the first one. I mean, most of the time, contingency fee agreements, those type of claims used to pertain to the RAF type matters. And we know with the tweaking of the legislation now, those claims are limited. So, so those claims are now redirected into GL claims, slip and trip claims, those type of claims where, you know, those contingency fee agreements come into place where a person has suffered a personal injury. So it goes into GL claims and medical malpractice claims as well. So we're seeing a rise in those type of claims because there's no more spin off into the RAF type claims. Also, we see it in the construction industry. So whereas insurers are now, for instance, on SANRAL claims, where there is a lot of incidents on the roads, you will find an assets insurer referring the matters back to SANRAL for recovery of the monies that they've lost. And then also personal injury claims get inflated in that way. So you'll get the consultants that are contracted to SANRAL that are now joined into these claims. So from a GL perspective, if you're working on a road, if you're a construction company that's doing road maintenance, etc., from a GL and PI perspective, you're drawn into those claims, and we're seeing an increase in those type of claims as well. From class action, we see them in product liability claims. Listeriosis has been one of the class actions that has been brought about, as well as litigation funder. Listeriosis is also subject to a lot of litigation funding at the moment, and we see that's how that has been affected by both class actions and litigation funders. Social media, you know, it's a huge evolution in terms of how we used to handle claims before. Now it's more of you know, before an insurer used to be seen as a person you buy a limit of indemnity and that's it. But now it's a complete partnership. We understand and we appreciate the risk that our insurers as well as us can face in terms of social media and in terms of the reputational damage that it can do. And I think now when you buy a limit of indemnity, you buy a specialized claims team, you buy a specialized network of attorneys and public relations specialists that can get you through these type of events that can have a huge impact on a business. In fact, it can destroy your business in a social media type of exposure. So that is kind of what we're seeing. That is how we're evolving to keep up with those type of pressures. So yes, Susie.
Thanks, Kams.
Okay.
I see we do have a question from Via. Do entities, oh goodness, I lost the question, sorry. Do entities have rights of recourse for the fake headlines of social media against the likes of Twitter or Facebook, which implicates entities wrongly and leads to brand damage?
I might hand at that if you like, Susie.
Yes, please, thanks.
Kim, please add in and tell me what you think. But
Okay.
yes, obviously, anybody that's affected by statements causing harm that can be quantified in money are entitled to pursue a legal remedy. Our law of defamation has always been used for that purposes. The particular obstacles or challenges rather that one faces when pursuing recourse against social media giants like Twitter and Facebook is one where you're forced to sue, possibly America, which would make it an expensive exercise. Secondly, the defenses to claims like this are are rife. There are many defenses that can easily be raised, the most prominent one being that it is public opinion. Because remember, social media networks by their very nature is a public forum where it's the stakeholders are all individuals. So we band together to form a social network. So everything that is said there is notionally covered by public opinion or for truth and public benefit. However, regulators around the world have taken social media giants and networks to task over how they manage and regulate their affairs when it comes to allowing the passage of fake news and harm-causing content. So you would have seen Facebook is forever dragged in front of the regulator in the USA and periodically fined sometimes very large amounts for allowing its networks to be used for purposes that cause harm or damage. So I think you will carry on seeing that trend amongst regulators around the world, including our own, now that we have the information regulator under POPI. I think that type of regulatory enforcement is most likely. But it comes as cold comfort to those of us who have been defamed by an angry neighbor or something like that.
Absolutely. And just to add to that, just to add to that, of course, then the question is actual damages. And Justin mentioned that there are a number of defenses to these types of claims, but one that is always difficult is to prove what actual damages you've suffered as a result of statements made. In terms of damages suffered for having seen something on social media, and I think the comment made was, you know, the trauma it's caused. You remember, it is a voluntary platform, so you've elected to be on that platform and to look at what's on that platform, and that also has to be taken into consideration. So if you're an oversensitive viewer, then you can mitigate the damages by simply removing yourself from that platform as well.
Thanks for that. I see Yolanda has her hand up. Do you have a question for us, Yolanda?
Maybe she's just waving at you, Sue.
Hi.
Been up for a while, maybe it was a mistake.
There was a question about
hand.
cyber and hacking. I didn't see the total question, but I don't know if someone can read it off there.
Mamsie, is there another question?
Yeah, there's a question from Patricia, wondering about the advent of claims following the cyber hacks, etc. For example, the current situation where Transnet was hacked and resultant declaration of force majeure and exclusion by reinsurers for cyber issues. Is this not also something that is on the rise due to changes in our society? Your thoughts?
So I wonder if you could repeat that. It seems that we've got two questions there, one dealing with cyber attacks and one dealing with force majeure.
Sure. So the first one was the advent of claims following cyber hacks. For example, the current situation where Transnet was hacked and the resultant declaration of force majeure and exclusion by reinsurers for cyber issues. So that was a cyber portion of that.
Yeah. So maybe let me start with that one. I mean, I think the point is we're all well aware that the number of cyber attacks and cyber claims that we're seeing is on the increase. And that's why we're seeing insurers writing standalone cyber policies. Commonly, maybe you can comment further on this as well. But a lot of your policies will have specific cyber exclusions in your general policies, and then you will have your standalone cyber policies to deal with those particular types of claims, because they are so bespoke. And those cyber policies will then have specific requirements, underwriting requirements in terms of checks and balances and systems in place to protect insurers. And make sure that insureds have certain systems that are compliant. But the short answer to that, 100%, we're seeing a lot more increase in the number of cyber attacks, which ultimately is going to see an increase in the number of cyber claims.
Definitely. And we've got a lot of that information as well on our YouTube page, because obviously we've got an extremely impressive cyber product ourselves. And you'll see multiple talks from Ryan, our product head, and Candice as well. If you go to the I2 Special Risks YouTube page, you'll be able to see more on that conversation as well.
Thanks, Mamweti. You managed to sneak in a punt for cyber there. I'm very, very impressed. You're
I'm
obviously
very brand
skilled at,
specific, Melita. You
facilitating
can't.
these sessions. I think we're running short of time. I don't know if there are any more questions, but thanks everyone. And I think, just to wrap up, we're looking at increased severity costs. We're looking at claims that are more likely to breach policy limits and possibly exceed them, higher legal fees, and organizations, more likely to be held accountable for what they do. And as insurers and brokers, I think we're just going to have to up our game and become better skilled at dealing with the social context in which we operate, and being aware that societal factors like we've been discussing are having an impact and are likely to have a much bigger impact on us in the future. And yeah, that's my wrap. And thanks so much to Kim and Justin. It's been a really interesting talk. It's been lovely chatting to you guys. And thanks to my GL team, and to Carmony for joining us, and Mamweti for jumping in there. And I'll hand over to you, Mamweti, to do your usual good thing of saying goodbye to everybody.
Thank you. Thank you to all. Thank you to all the geriatrics on the line. You guys have certainly earned your mid-morning nap. We will not bother you for the rest of the day. Thanks, guys. As they say, boomers know best. So we appreciate all of the expert opinions on the line today. Thank you so much, Kim and Justin, for your expert opinions, as well as our really famous and really on point GL team and our #1 claims team representative, Carmony, here. So thank you all. Again, these recordings go on our YouTube page, and you can catch today's session again if you want to just go through it again. But we appreciate everyone on the line, and have a great rest of your day, guys.
Thanks for having us.
Thank you.
Cheers all.
Cheers,
Bye.
everyone.
Cheers.
Everyone, cheers.
Everyone.
Cheers, everybody. Thanks, Justin and Kim.